Good evening. Welcome to the Center for Comparative and Public Law. I'm Cora Chan, Director of the Center. It is our utmost honor to have with us Justice Manuel Jose Cepeda Espinosa to deliver a public lecture for us. There aren't very many people in the world who has made as great an impact on constitution design and implementation and in as many capacities as Justice Cepeda has. Justice Cepeda has been an indispensable figure in the peace process, the constitution-making process, and the advancement of human rights and equality in Colombia and beyond. He was president of the Constitutional Court of Colombia from 2005 to 2006 and justice of the court from 2001 to 2009, the year in which his term ended. During his term, he has delivered numerous landmark judgments. For those of you who are unfamiliar with the Colombian Constitutional Court, the Colombian Constitutional Court is widely recognized as one of the most creative and progressive courts in the world. It is a big deal in comparative constitutional law. The principles and techniques that it has developed has had a profound influence around the world. Principles on remedial remedies, on principles of proportionality, and so on. So despite its youth, the Colombian Constitutional Court has had a profound influence around the world, and Justice Cepeda has been instrumental to that. So register number one, capacity of judge and president of the court. But Justice Cepeda is also an attorney, but not just any ordinary attorney. He was co-agent for Colombia at the International Court of Justice in 2 cases initiated by Nicaragua against Colombia that ended in judgments favorable to Colombia. He was an arbitrator. He's an arbitrator as well. For 10 years, he was a member of the Court of Arbitration of the Chamber of Commerce of Bogota. And since 2010, he has been an arbitrator specializing in administrative law controversies. Most lawyers are concerned with everyday law. And not many of us are called upon to determine the political and constitutional fate of a country or countries. In 2015, Justice Cepeda was part of the negotiating team on transitional justice during the peace process in Colombia that culminated in a peace agreement in 2016 and the demobilization of the FARC guerrilla, putting an end to decades of bloodshed in the country that resulted in millions of displaced people and hundreds and thousands of deaths. So we're on to role 4, peace negotiator and politician. To continue with the list of amazing roles that Justice Cepeda has served in, he was a presidential advisor between 1987 and to 1993 for 2 presidents of the Republic for the creation of the Constituent Assembly, the new Constitution, and later for the development of the 1991 Constitution. In other words, Justice Cepeda was also a constitution architect. In 1993, Justice Cepeda received the Order of Boyacá and the highest degree of Grand Cross from the President in recognition of his role in the adoption and drafting of the new Colombian Constitution. Justice Cepeda, furthermore, was a law drafter. From 1991 to 1992, he drafted the decree laws that regulated the constitutional procedure at the newly created Constitutional Court, as well as numerous statutory bills on fundamental rights. He was, above all, also a diplomat. He was ambassador of Colombia to UNESCO and later ambassador to the Helvetic Confederation. In addition to the above roles, the role that I personally have got to know Justice Cepeda was the role of an absolutely outstanding scholar and a brilliant academic leader. So register roles 8 and 9 there. He has published on public law and fundamental rights is President Emeritus of the International Association of Constitutional Law, which is the preeminent constitutional law association in the world, was Dean of the Law School of the Universidad de los Andes, where he also taught constitutional law and is currently a member of the Directive Committee of the university. This brief introduction is unable to capture the full depth and breadth of Justice Cepeda's distinguished achievements, dedicated service, and what must be, I imagine, at times precarious adventures. But it does show how honored we are to be able to have this exclusive counter with him for 2 hours tonight, to see him in person. He will speak to us on the Colombian Constitutional Court and Fundamental Rights, responsive decisions with transformative impact. Let's give us a warm welcome to Justice Cepeda.
Thank you very much. Thank you so much, Professor Korat, for this very generous and warm presentation. I don't know what to say. It's excessively generous with me. I'm very grateful. I hope I will not disappoint you in this presentation. After this introduction, you would expect magic coming from my hands. No, it will be just a presentation of what the Constitutional Court has done in his 30-something years of experience. So, secondly, I am very grateful with the university, with the law school, with the Center for Comparative and Public Law for the invitation, including Stephanos' support. Very grateful. Thank you, all of you, for being here and having an interest in what the Constitutional Court has done. I was invited to present a panorama of the work of the court, attempting to explain why the court has, in a sustainable way, taken decisions that you would appreciate and judge, but decisions that have, as the title suggests, a transformative impact in Colombia. And then to focus on the protection of indigenous people's rights and how the court has managed very complex issues that involve really a challenge to the way liberal constitutionalism usually approaches ethnocultural diversity and cultural pluralism. I will speak for 45 minutes, 1 hour, but as I have been a professor, please free to raise your hand, to interrupt, to ask for clarifications. I will try, as I progress in my presentation, to make some pauses and invite questions or comments that may be helpful to clarify what I am trying to convey. It's difficult in short time to transmit what the court has done and to explain it, but I will try to do so, and excuse me if I go sometimes very fast so that we can cover a bunch of topics, perhaps too many topics. So I start by presenting an overview of my talk. I will quickly give an introduction about Colombia, but very quickly, then explain the mixed model of judicial review that we have, and then go topic by topic about the big issues of constitutional law that I have been analyzing, comparative constitutional law, look at basic rights, then social rights, focus carefully on indigenous people's rights, and then address, again, a general question on why judicial review in Colombia has been sustainable, what explains that, and end with some conclusions. I will not mention during my presentation the exact citation of each case, because this will complicate a lot what I'm going to say. But at the end, I will mention all the key decisions if someone is interested, and lead you to the web page where these decisions can be found, mostly in Spanish, some in English, translated. So let's begin. So a general context of Colombia in 5 points to understand a bit what we have. Of course, we have a very bad reputation as a country. You know that, a very bad reputation. Because of violence, because of conflict, because of narco traffic, we have that. But Colombia is Janus-faced. I don't know if you have heard of this goddess that had 2 faces, the goddess Janus. So we have this side of violence and crime, but we have another side, which is legalism. We are a very legalistic country where law is taken very seriously. That's why, as Professor Cora mentioned, a former member of a constitutional court was in a negotiating team with the guerrilla. Why? Why a lawyer negotiating with the guerrilla? Because even the guerrilla in Colombia considers that law is very important, even the law against which the guerrilla rebelled, and wants to have clarity on what would happen after the peace agreement is signed. So it shows how legalistic we are. We can say, and that's the second point, that these 2 faces are not in harmony. It's not the harmony of the goddess Janus. There is tension in this phase, in these 2 sides. And there is a permanent conflict of what I call the 2 dominions. Sometimes the dominion of violence tries to invade the dominion of the rule of law. And sometimes the dominion of the rule of law tries to take, again, control and establish rules and order and rule of law in certain areas. The peace agreement is an example of that. How law can help building peace and establish law and order in certain areas of Colombia. That's the second characteristic. The third one is that Colombia, but the Constitutional Court is always at the center of the storm. You imagine these tensions. These tensions generate hurricanes, tsunamis, political, economical, social, and everything flows to the Constitutional Court. And the court has to address very difficult issues, always at the center of the storm. In a country that is very unequal in all senses, we are one of the most unequal countries of the world, in a country where we have managed to diminish poverty fairly successful way, have a reasonable economic growth in the region. We are the second after Chile, although in the last year we are going down in economic growth. And third, a very diverse country. We have not only diversity at a regional level, but diversity at the cultural level. And that's why the decisions of the court concerning indigenous peoples are so important. We have over 80 different indigenous cultures in Colombia. Fourth point, the court is very independent. There is a tradition of independence of courts in Colombia. It was built for a long time, I would say for almost 100 years. Not go into the detail, but it's a very independent judicial system and a very independent constitutional court. And finally, we still believe, in spite of the interventions of the court on all kinds of topics that are politically hot in Colombia, we still believe in the separation between law and politics. Not in a naive way. We understand that the court has discretion to interpret. Of course, must respect certain bounds, certain limits. Is that the court is not an automatic applier of clear constitutional rules? Of course not. But we believe that the court works within the law. Even if the decisions have political implications, even if different judges have different philosophies on how to interpret the Constitution. But in the country in general, we still believe in the separation between law and politics. So just a political decision of the court is not legitimate. It's not considered accepted. Good. What is the model that we have in Colombia concerning judicial review? We have what we call the mixed model. I don't know if you have looked at the different models. There is the American model, which is diffuse. We have the European model, mostly the German, the Austrian, inspired by Hans Kelsen, which is the centralized model. We have both. We have a mixed system of judicial review. And this is how we got there very quickly. So it started in 1886. So the tradition of judicial review in Colombia is over 100 years old. Started in 1886, where the president had the power to veto on constitutional grounds acts approved by Congress. And if Congress overrode the president, the case went to the Supreme Court, not the Constitutional Court, the Supreme Court that existed at the time, and the Supreme Court was the final arbiter, decided what the Constitution meant. Our Marbury versus Madden, so our first case of unconstitutionality was in 1887 because of this procedure. Then, in 1904, there was a reform that introduced the exception of unconstitutionality. That meant that any judge in the country could say, although this case should be decided according to this statute, I, as a judge, consider that this statute is unconstitutional. So apply the exception of unconstitutionality, didn't apply the statute, I gave preference to the Constitution for deciding the case. Since 1904. Then in 1910, an actio popularis was introduced and allow any citizen, so any person at the time over 21, now over 18, to go directly to the Supreme Court and challenge an act of Congress as unconstitutional. So it gave a lot of power to each Colombian citizen. And these actio popularis triggered judicial review in the abstract. That meant without any concrete controversy. And the Supreme Court at the time decided in the abstract whether the statute was compatible with the Constitution or not, and the decision had erga omnes effects. I underline the date of that, 1910. The inventor of abstract judicial review in a concentrated way, Hans Kelsen, and then member of the court, wrote his first papers in 1920s. So this is before. So in practice, we had what Kelsen later created and conceptualized. We didn't conceptualize it. It was not theorized. It was an institution adopted in a constitutional reform. Kelsen then became very influential in Colombia because, oh, now we have a theory. Now we know what we did. But at the beginning, it was not a theory. It was an institutional reform and a practice. It has been used since then. Then in 1968 came ex officio review of legislative decrees. So the president issued decrees that had force of law. He had this power on certain conditions. These decrees went automatically to the Supreme Court, and the Supreme Court reviewed the decree. It's like if Trump today said, I'm going to impose tariffs because there is an emergency. This decision will go to the Supreme Court automatically, and the Supreme Court will review this decision because it was an emergency decision that with legislative effect since 1968. Then came a huge constitutional reform mentioned by Cora, changed the Constitution and created the Constitutional Court. The Supreme Court lost the powers, and in 1991, the Constitutional Court received all these powers I have mentioned, and in addition, the Constitution granted very important additional powers. First, ex ante review of referenda. Every time there is a popular referenda in Colombia, whatever you call it, we have different mechanisms of direct democracy. It should go previously to the Constitutional Court, and the Constitutional Court reviews and decides whether it's constitutional or not before the people vote. It has happened several times. Then also in 1991, we have ex-ante review of statutory laws. These are special laws that regulate basically rights and participation. And these laws do not enter into force before, unless the Constitutional Court has already reviewed the statute and said it's okay with the Constitution, because they are so important. And then what has produced a lot of impact, tutela. We call it this way, is in English would be a writ for the protection of fundamental rights. This is not abstract control as all the previous powers I have mentioned. This is concrete. Any person in Colombia, any person, not any adult, any person, can go to any judge in Colombia and ask for the protection of his or her fundamental rights. And the judge must decide in 10 days. Then there can be an appeal, and the appellate court must decide in 20 days. And then all this is sent to the Constitutional Court automatically, and the court has certiorari, picks the cases the court decides, and renders the final decision. If the court doesn't select the decision of the lower courts, the decision of the lower courts stands. If the court selects, the decision of the Constitutional Court stands. This is what we call tutela, so a specific instrument for the protection of fundamental rights. What's the general impact of what I have mentioned in quantitative terms? First, in total, the court has rendered 28,753 decisions since 1991. That's a lot. Secondly, of these decisions, the C, that is the abstract judicial review, constitutionality decisions, are 7,379. The tutelas are 20,763. And these SU decisions are tutelas that unify. We call it unification sentences. That unify, because of course with so many cases there are sometimes contradictions, so the plenary of the court intervenes and unifies the position, the interpretation on very important topics. 611. So there's a lot of work. I cannot explain this in the remaining of the time. I will focus on the most important cases. Well, I will leave also very important cases out because it's too much, but I will try to give you a general flavor. So let's go quickly to basic rights. I stop here. Is there any question concerning these basic elements? Yes? I was wondering if
in your last slide, if a statute has passed the ex ante review, is a ex post constitutional challenge still possible?
So that's a very good question, very technical. So the court at the beginning said no, because the ex ante review had to be total, had to cover everything possible under the Constitution. Then, let's say 7 years ago, the court said that there could be exceptions when from the application of the statute, something clearly out of what could be anticipated happened. But there is a heavy burden for that. It has happened very few times.
Thank you so much. Maybe I'm jumping way too far ahead, but then I think there are some really exciting elements I want to ask about. So the first one is about the idea that you can have decisions rendered in 10 days. Now, I find this fascinating because, for instance, I'm very used to, say, English law, where there are so many immigration cases, like asylum applications. And if all of them have to be decided within 10 days, I can't imagine how they could have been funded, like how the government could have funded all of that being done so efficiently with so many judges and counsel, I suppose, being offered for free or at a reduced level, at a subsidized level. So that's question one. The question two, which is about the ex-ante review of referenda. Because you talked about the courts being at the center of the political storms sometimes, I could imagine that being sometimes quite politically controversial. So I wonder if the courts on those occasions may have been more differential than otherwise because of the repercussions that could occasion. Thank you.
Wonderful, wonderful point. Yes, wonderful. So, of course, 10 days is so short, so short. At the moment, there was also judicial reform, and the judges were not happy. They anticipated a lot of work. But in this reform, they received support. Their salaries were augmented. There were all kinds of programs to familiarize the judges with the new constitution. And at the beginning, most judges denied the tutela, said, in 10 days, no. You don't have the right, you don't have the right, deny the right of everybody. But then the higher court said, no, well, here there was a problem and started to concede. And then the Constitutional Court intervened and started to guide the judges on how to interpret rights, sometimes in easy cases, sometimes in very difficult cases. And gradually, the judges have become constitutional judges that value what they do to protect the citizens. Now the judges that opposed all this work feel proud of their responsibilities and what they can do to the citizens. That's the first one. And since all the judges must decide, the burden is distributed. But we have a lot of problems. We can go into the detail. The secondary referenda, yes, the court tends to be deferential. It has never stricken down a referenda except once, because it was a very hard case. It's called the second presidential re-election case. It's the only case. We can go into that if you want afterwards, but basically the court did not accept that the president amend the constitution to be re-elected twice in a row. So our term is 4 years. One re-election the court accepted, but said only one. Then the president said, after being re-elected once, I want to be re-elected again. So we went to stay for 12 years. And the court said, no, that's unconstitutional. Stopped. And the president respected the decision. That's the only case when this has happened. Otherwise, the court is deferential, although it's deferential in a calibrated way. Let's put it this way. I don't know if there is another question. Or Stefano, please.
Yes, very briefly, and I understand this might be slightly off topic, but I'm very interested and I would be eager to know more about the history behind the Actio Popularis and the introduction of this Kelsenian system anti-litteram. It's fascinating. You know, how was developed and
it's incredible. But as I mentioned, there was no theory behind. It was out of political necessity. So we had in this Janus phase country, we had a period, one of the many, of a conflict between the two main parties. These didn't end it. These led to a precedent that was very harsh, very harsh, and that managed to get support of the contrary party. This precedent considered it was important to make a reform to the 1886 Constitution, convene a Constituent Assembly, and in this assembly, there were participation of the opposition. And the big question arose is how can minorities, political minorities, be protected? And so there were several reforms to empower political minorities. And one of them was presented at the time, the right to challenge any unjust statute. We call it unconstitutional statute, to challenge any unconstitutional statute through institutional channels. So you don't have to go to civil war. Let's say the majority adopts a statute that oppresses the minority. You don't have to go to war. Just go to the court and challenge the statute. That's why it's an actio popularis, very easy to present, not a technical. You don't need a lawyer. You can do it as a citizen, because it's a political right of a citizen to request that the Constitution is respected. That's the idea. And so we speak in Colombia, the way it was, the low density theorization was, this is an instrument to protect the political minorities and is an instrument to ensure the effectiveness of the right to the Constitution. You have the right that the Constitution is effectively applied. And you have the right to defend, to collaborate in the defense of your Constitution. Nothing of a theory of hierarchy of norms, nothing of Kelsen there, nothing at all. But more or less, this basic principle. You have a right to the Constitution, to the highest norm. Yeah. Yes. Sorry of so quick answer to a very, very difficult topic. Yeah. So I will go quickly through these three sets of rights: basic rights, social rights, and then indigenous people rights. I will not go into the detail of the arguments. I will not quote the articles of the Constitution applicable. Of course, in all the cases, the text of the Constitution is relevant, very important, and the court is very careful in building the argument, very careful. We have very long decisions. We have dissenting opinions. And so there is internal accountability, and the court tries to be very, very careful. So let's pick the basic rights. I use DALE in Spanish because the basic rights at play always are dignity, autonomy. In the text is freedom of the development of personality, but the court has said this is self-determination, this is autonomy. And then we have liberty, of course, and then we have equality. And the court plays with all these four in all these cases. I will go very quickly. All these are developed in the Constitution, clearly articulated. Equality of religions and religious freedom. So Colombia is a Catholic country. Most Colombians are Catholics. Nevertheless, very soon, the Constitutional Court, in the first year of its working, interpret a clause in the Constitution that not only protects religious freedom, but equality of religions. And the court had to answer whether the treaty that Colombia had with the Vatican, we call it the Concordat, was compatible with equality of religions. As you know, a Concordat gives privileges to the Catholic Church, all kind of privilege. I will not mention all of them. They're very important privileges that were there for 100 years. And the court said the Concordat violates the principle of equality of religions. This was like the Big Bang, or the bang. When I visited a lot of temples here in Hong Kong, I love to visit temples, and I was informed that it's a tradition when you enter a temple and you want to call the attention of a god, you you bang to call the attention. Well, that was the bang in Colombia. It was, oh my God, what is happening here? How can it be that in a Catholic country, the treaty with the Vatican is partly unconstitutional? Something changed here, and everybody started to pay attention. What is happening? It was respected. It was a crisis with the Catholic Church. I will not go into details. If you have interest, we can go into that. But it was a very important decision that showed that the change was serious, had to be taken seriously. Then I can mention other decisions, but let's go quickly. Suddenly at the mid-90s, the criminal code article on merciful homicide. I don't know if you have this here. So when someone is about to die, and let's say a member of the family or a physician helps this person to die, it was a crime in Colombia. It was considered merciful homicide. It was homicide, but out of mercy, so the sentence was lower, but there was still prison. It was challenging the Constitutional Court. And the Constitutional Court said, well, yes, of course, you cannot allow killing a person that is terminally ill or gravely ill. But there are certain conditions in which you cannot punish the physician that helps a person to die with dignity. A person has, out of dignity and autonomy, the right to decide how this person considers will be a dignified death. And the court established an exception to the criminal law, saying that when a physician, with the clear and express consent of a terminally ill patient, helps this person to die with dignity, the physician cannot be punished. Of course, also in a Catholic country was a second bank. Wow, that changes. It's not a relation with the power, it's a relation in all society. This decision then evolved. That was a 1997 decision. Then in 2021, the court expanded, because of other case, I don't go into the details, expanded the reach and said, it's not just for terminally ill patients. It's for any patient that is undergoing great physical or psychological suffering as a consequence of a very grave illness or a very intense corporal damage. So not only terminally ill, and it was taken, and there was no controversy in Colombia. It was incredible because it was a huge expansion. So this is to show that the country accepts these kind of interventions, and not even the church reply and attack. He said, well, okay, it's assimilated what the court did. It's very difficult to apply in practice, and there has a lot of controversies because it's a very sensible and topic. Then abortion. Abortion took more time. The first decision that produced a change, transformation, was in 2006. Abortion was always a crime in Colombia. And the court in 2006 intervened and said, a woman and a physician cannot be punished for abortion in the three classical circumstances, which is when the pregnancy is the consequence of a crime, rape, incest, forced artificial insemination of any crime. The woman can decide, and the physician, and they cannot be punished. Second, when the fetus has a malformation that makes the fetus non-viable. And third, when the life of the mother is at risk, or the health of the mother is at risk, considering both physical health and mental health. And these should be interpreted widely and without undue barriers to access the abortion. This generated a huge controversy, The church intervened, the nullity of the decision was requested. Well, the things stood. It was, I was at the time on the court, so if you want, I can share certain elements as much as I can, and sometimes some things I cannot share, but it was very harsh. Then time passed, and there was a new case, and in 2022, the court went even further. And this time, there was not as much controversy. In 2022, the court said, yes, these exceptions are okay, But there is a need to interpret the Constitution in context. And the court received all kind of information from civil society organizations that showed that the three exceptions were very difficult to implement in certain areas of Colombia. There are certain areas of Colombia where, for example, certain clinics will refuse to practice an abortion. Or there are areas in which the peasant woman will not have access in time. So we'll arrive there already with a big belly, and so the physicians will hesitate. Although there were no terms, the physician would hesitate. Time passed, tutelas had to be posed, and then the baby was born. So the court, and there were internally displaced persons and Venezuelans that immigrated. And so the court looked at access to abortion and the impact of the factual barriers to abortion in poor women, and decided that although the exceptions were okay, in context, there were barriers for accessing abortion, and the court said, so abortion should be decriminalized up to week 24. And after week 24, the exceptions apply. But let's get rid of the exceptions in this time. There was not as big controversy as in the first one. What is interesting about this decision is that the basic argument is not the kind of argument that we have seen in the United States. It was never in Colombia a pro-choice or a pro-life controversy. Never. And the court refused to argue on these terms. The two basic elements of the decision on abortion were first, dignity, and second, the sexual and reproductive rights of an autonomous woman. Why dignity and how it played? Because the court said that if abortion was always a crime, it meant that the state was utilizing the woman as an instrument for the reproduction of the human species. So it was cosificating the woman. It was not treating the woman as a human being, but as an instrument to populate Colombia. And that was against dignity. That's why we had a majority. Otherwise, we would never had a majority for this kind of decision. And secondly, the court said, and of course, this dignity is linked to the sexual and reproductive rights of women. These two were the key ones. In the second decision, all these counted, but also equality, because the court looked in context what were the situation of different women, actual real women in different parts of the country. And this was a third element, in addition to others, but I will not go into the detail. Then same-sex couple. We call it this way, but it's really the right of individuals to define their sexual orientation. So in Colombia, that was accepted very early, after 1991. People could change the name, could change the sexual orientation. Students could dress as they wanted. So there was a scandal because someone dressed, it's okay, you have the right, you can go to school, no problem. Even if Catholic school cannot treat you, cannot expel you, you have to continue, you have to treat with dignity. But the big question was the couples. And there is what. So in 2007, the court addressed the issue of the couple. And in 2007, the court did the first move and protected the couple that wanted to register what we called marital union. It's a de facto marital union. If two individuals have lived together for more than 2 years, they can register as a marital union. The law was drafted in heterosexual language, And the court said, no, no, it should be extended to anyone, even couples of the same sex. Why? And it was a unanimous decision. Why? Because the court considered that at the time there was no protection for same-sex couples. And so the court said there is an absolute deficit of protection of equal dignity. And this reached a unanimous decision in the court. One judge said, I will have used another argument. Okay, but I concur. I accept that this is a good decision. So then came marriage. And the court, using the same line of argument, deficit of protection of equal dignity plus certain elements, said, yes, can formalize a marriage. But the court said, I am no one to say to Congress or to legislate how this should happen. What I can say, and the court drafted a remedy, is that if Congress does not approve in these many years, short time, a statute regulating marriage for same-sex couples, the old civil code that applies to everybody should apply. Congress did not approve a statute, and so marriage, the old traditional marriage, started to apply to same-sex couples. In practice, this became very difficult. So you can marry in Colombia before a notary or a judge. Some public notaries and judges said, no, I will not marry you. And so there was a controversy, and they used tutela, that I mentioned. And the tutelas were decided by different judges. So in the end, the court said, I'm going to accumulate all the tutelas and render a unification decision. And the court rendered a unification decision saying that judges and public notaries cannot argue objection of conscience not to exercise their functions, and they had to practice the marriage in an equal condition as is stipulated in the code. Then came the third topic, adoption, of course. And the court moved on and said, yes, same-sex couples can adopt, always following the same line of deficit of protection, and incorporated an element which was very important. He said, we have never held that the family is a relevant issue for the analysis. And the court said, in addition to all our arguments, since we already decided about marriage, we should also hold that same-sex families can evolve and can therefore have children and can adopt if they want. It's part of the diversity of families that we have in Colombia. This was not as controversial as the first ones, because time has passed and it was, the population accepted and the main actors accepted. Then women's rights. We are a very machista society. We are, I don't know if the word macho society, because of the traditions. But this has evolved. And women now participate. There are more women students than men students. In certain sectors of the economy, the women dominate, both in terms of numbers and in terms of leadership. But in politics, it's very difficult. So the Constitution says that women should have equality, of course, there cannot be discrimination, but in addition, women have the right to adequate participation in the highest levels of public administration. And there was a statute, one of these statutory laws that I mentioned, that is subject to ex-ante review. And this statute said at least 1/3 of all high administrative posts should go to women. The court reviewed that and said it's okay, and extended that to the ministerial cabinet. And so at least 1/3 of the members of the government must be women. And there are other decisions to protect the equality of women. I stop there. If there's any question, any comment, happy to answer.
Sorry, I have this inclination to keep asking questions. My former teachers like Cora have been at the front of this.
You had a very good teacher, I see.
My question is this, because I've noticed, like you've mentioned, the history of the progression of the case law. A lot of it is basically once the court has established a premise, like for instance, the case law relating to same-sex couples, you can see the court has established a premise and you can use it to expand the protection of the rights. And the reason why, however, where this has not happened as successfully or smoothly in our jurisdictions is that usually there will be some immediate pushbacks or the courts will be thinking, okay, defer, or okay, restraint. So I'm curious in what allowed the court to keep expanding using the same premise, the rights that follow from the premise.
Very important question that has to do with different factors. One very important factor is the way the court decides. As I mentioned, for example, in the same-sex couples, which is clearly a progression there, the court takes a lot of time to try to build consensus every time a very important step is going to be taken. So the first decision on same-sex couples was unanimous. So when the court is renovated, it's not renovated in total. There are 2-3 judges that arrive. They arrive to a community that is clearly in compromise with the decision in which they participated and they supported. Secondly, the way we deliberate. In the court, the Constitutional Court, the deliberations, although after COVID this changed a bit, unfortunately, but we deliberate in person for very long time. It's not that you write your opinion and you send it to your colleagues and then memos are exchanged and the clerks intervene. Of course, there are clerks, the judges discuss with their clerks and everything, but there is a moment of truth. It's when you go and sit with your other colleagues in a room and you start arguing and deliberating. So if you arrive there and you try to change, you will have there a lot of colleagues that said, well, why? And why this not? And why? So you are subject, I don't know what kind of exams you have here, but in Colombia we call it preparatory exams. It's oral exams before a kind of professors that fire at you a lot of very difficult questions. So the new judge that arrives there and tries to, let's say, change, is subject to a bombardment of questions that make this judge think twice whether we'll expose him or herself to that. That's the first thing. The second thing, it has to do with the way the political process works. As I mentioned, Colombia is a very dysfunctional. What I describe at the introduction is a very dysfunctional political system. One of the dysfunctions of the political system is that it doesn't address issues that are very important for the people. It's a problem of political representation, a problem of accountability, and a problem of responsiveness. The political system has these dysfunctions. But the politicians agree with certain of these topics. So basically they say, well, let the court take the decision. And of course, there's a reaction. But since we are a legalistic country, this reaction goes to Congress. So in all the cases I have mentioned, there was a group of members of Congress that introduced either an amendment to the Constitution or a statute in a way to overrule the court. Let's find a way to overrule the court. So this goes to Congress. There is a debate, and Congress doesn't follow. It prefers to let the court do what the court has done. So it's not that the court intervenes in a black and white way and everybody is silent. No, the court intervenes with decisions, as I mentioned, in the case of marriage, that throws the ball back to the political process, but fixes a deadline. The political process reacts or doesn't act. And then in this dialogue, very informal dialogue, in the end, there is accommodation. There are issues where it's very difficult, like the marriage of same-sex couples. There is the judges that rebel, the public notaries that rebel, with the support of some religious organizations. I can go into the detail. But then the court has ways to gather again all the cases and to intervene again, specifically addressing the issues. So this is why it has been possible to advance. In addition, there is a final one is we tend to be a consociational, dysfunctional democracy. So we don't have extreme positions in the political system. We try to find common ground. Why? Because of this Janus phase, we have violence. So if those that are within the system fight too much each other, they say, what are you doing? We have here really problems with the guerrilla or with paramilitaries or with these criminal organizations. Let's calm down. Let's try to find common ground. Let's work together. We have this thing. Of course, there are moments of political confrontation, very difficult ones. We have them. But this is another very important contextual factor. Of course, the decisions are long and very well argued. And we have a staff of clerks that continue in the court. So when a judge arrives, a new judge arrives, usually, since the cases are so difficult, wants to work with persons that already have worked in the court. So the clerks that have been there continue, or there are new clerks that went out but come back. And so there is, I would say, this critical mass of thinking, of constitutional thinking, that influences the new judge that arrives, that discusses with his or her clerks, and her clerks give them an opinion on what the court has done. Sorry for this long answer, but it's also such important. It's very important. It will go to the end of my lecture. Yeah.
Justice Cepeda, I didn't understand fully your discussion of the two cases concerning same-sex couple. In the first case, you said that the court's ruling was based on a law about a couple living together for 2 years. So what did the court actually hold for same-sex couple who have
It held that.
in 2 years?
So the law said if a man, that was wrong, if a man and a woman live together for 2 years, de facto, they can go to a public notary and register that they have lived in community for 2 years, and these will have patrimonial effects.
Okay, so
Patrimonial effects. And so the law was challenged, and the court said, but why? The law says the man and a woman. Why a man and a woman? Why? And so there was there's a deficit of protection of individuals with equal dignity. And therefore, the court modulated. It had a modulated decision, and we have what we call conditional constitutionality decisions. You know very well the German system, I know. So the court said the law is constitutional on the condition that in addition to men and women, persons of the same sex, couples of the same sex can register their marital union. So if you want, it conditioned the constitutionality. We had that since 1910. The court could say this statute has two interpretations. It excludes same-sex, or we can include same-sex in spite of the language. If we do not include same-sex, the statute is unconstitutional, we have to strike the statute. If we strike the statute, heterosexual couples cannot register their marital unions. It would disprotect all these heterosexual couples. So why strike it down? It would disprotect them. So the court kept the heterosexual and added the same couples.
Yes, thank you. But what I don't understand is that for a heterosexual couple, why do they have to bother about living together for 2 years and then registering? Because a heterosexual couple can get married at any time.
Oh,
So
that's a very important question. So the answer is incredible. I don't believe the answer. I tell you, I don't believe it. But I read it in statistics. It turns out that Colombian women do not want to marry. Yes, do not want to marry. Why? Because in a macho culture, the woman says, if I marry, the man will think that he has rights over me. I will not marry. So there's a problem. What happened with couples that live together, share goods, share their work, build a life? The woman will be disprotected. So the Congress intervened, adopted this statute, say, well, you don't need to marry, but for patrimonial purposes, if you register, all you have built in common will follow the marriage rules in patrimonial terms. In patrimonial terms. That's why. Why 2 years? Because, well, sometimes couples are for days, for months. So 2 years is basic stability. That was the decision of Congress. It had been challenged, but the court said, well, 2 years, the Congress can decide. If it's 2 years, 1 year, I will not decide on the number of years.
What happens after the second decision? You said that the second decision requires the Congress to legislate on same-sex marriage. So did Congress legislate?
Congress debated. So there were bills introduced, and some bills said, let's extend automatically the civil code marriage. Others said, no, we have to create a new form of marriage. And there was a huge debate. There was not a majority. So no statute was approved. The deadline arrived. And so the civil code started to be applied.
I was wondering, other than like marriage, traditional marriage between like heterosexual couples, so homosexual couple, is it the only way for them to get married, or are there any other methods, like civil unions or?
Yeah, so there are different unions, marriage is one of them, is the traditional, the classical one, but there are other contractual ways, like you call it civil, contractual ways of doing it. But after the 1991 Constitution, it was said that any religious marriage has automatic civil effects. And all marriages can end by divorce. Even a Catholic or a Jewish can end by divorce in the civil effects, not in the religious. Each religion decides what to do with the religious aspect of the marriage, but in what is the civil effects can end. So we have different forms. And
Hello, I think my question would be a little bit not of the legal question, but that's a general background. Like, it is really amazing to hear all this progressive and also the beginning of this constitutional and also the progress in it at now. I'm from a country called Myanmar. So we also have this very rigid constitution in our country, which is designed by the military. And the constitution is like, sorry. So we have that, like, and also you also mentioned that even the guerrilla in your country, when they when they have civil war, they still have this kind of relying on the court system to some extent. In my country, we also have like more than 70 years of civil war conflict. And you briefly talk about as well, like in the classroom culture, the professor asking question, and also the way the debate and also the constitutional debate that when you guys are like that kind of things, I think. So I think right now even Thailand try to copy us, like when it's come to the constitutional rigidness, that's gonna solve this political elite. So for us, for my country context, like everything seems so rigid, and also in terms of legal environment, like lawyer is not highly regarded profession in my country. No offense to people here, and also like systematically it is very, and also the peace negotiation never, when they have the table, but they have the talk, but never walk the walk. So that kind of, how could we came about that kind of, since our colonial independence back in 1948, there is not much progressive. So what kind of approach would be, given your country experience, would be something that we could learn?
Thank you very much. They're very tough questions, and I would love to discuss afterwards. But I tell you that, in my opinion, it's very difficult for someone from abroad to really give advice on the very difficult issue you mentioned. For my experience is that you need to know very well all the elements of the context, of the culture, of all the nuances to really contribute. So I will love to discuss further afterwards. You're very important, but we share something. Is that in Colombia we say that we have a lot of lawyers, and lawyers are very well respected. But in any case, we say that in Colombia, every person is presumed to be a lawyer until proven innocent. So this is how many lawyers we have. So, okay, and there's other question.
You're mentioning like the forms, and then I was wondering, let's say you mentioned about the registration for the heterosexual couples and household. So I assume they have lived together 2 years, but then if women or perhaps they refuse to register, are they still entitled to that like married couple? Or
if they do not register? No, if they do not register, we are in a different situation. And I can mention one case, also in the beginning of the 90s. It was a situation in which a couple lived together, did not register, bought a house. The credit to buy the house, the bank credit, was taken by the man who paid the credit. The man had married before, had 2 children, and the man died. And so the civil law, the traditional civil code norms gave the house to the kids of the man. Why? Not because it was a man, but because there was no marriage, there was no marital union registered. So the woman didn't have, according to the traditional civil code, any right over the house. This woman used tutela, went up to the Constitutional Court, and the Constitutional Court said what I said, but that's constitutionally wrong. This is a consequence, but that's constitutionally wrong, because woman lived for, it was like 15 years with the man, and her work contributed to the building of what they constructed together, including the possibility of the man to earn the money and pay the credit. The lawyer on the other side said, but the woman didn't have a profession. The woman did not work outside. The woman stayed at the house. And so the court said, yes, but the work of the woman in the house has economic value. It's not for free. It has economic value. Should we assign economic value to the work of this woman? So you cannot give the house to the kids and leave the woman totally out. And so there was a huge controversy. You can imagine what happened. But in the end, the woman had a right to a portion of the house because of a constitution, not because of a statute, but because of the constitutional intervention to protect the value of the work of the woman, even in-house. So it gives right to the woman. Let's say this is the answer to you is yes, the woman will have right.
So, on touch, that this case could possibly expand rights for non-marital or non-marriage couples, regardless of sexual.
Yes, of course. In this case, it was not homosexual. It was heterosexual.
Yeah.
It was an heterosexual. Yes. But you have to battle. That's the difference. If you register, you have to battle. If you don't register, there will be a controversy. There will be a harsh battle. But the constitutional law will give protection to the woman. Continue. I'm sorry, I'm taking too much time, but wanted to answer the questions. So very quickly, I move to social rights. Oops. I'm doing something wrong. Okay, social rights. Oof, I'm going to go very fast. So most constitutional litigation in Colombia is about social rights, not basic liberties. Social rights are very important. They are protected in the Constitution. At the beginning, they were considered non-justiciable. But then the court developed a jurisprudence and made them justiciable. And these are the basic, very quickly. First, the court, in the beginning of the 90s, says, out of dignity and other rights, I'm not going to do it, there is a social right to a vital minimum. In certain constitutions, a person, for example, a pensioner, an old person, cannot be left without anything dying because there is a vital minimum. It's not that it's going to be rich, no? Minimum subsistence right that can be protected in concrete cases. That was a very important decision at the beginning of the 90s. Then came another controversy in the mid-90s concerning a social right. It was a children's case. Well, they are different, but the most important is the children's case. It's in Cartagena. So the municipality started to build the sewage system. But since we are a very dysfunctional country, stop at the middle. So it was a chaotic, it was contamination. The children were playing there in very unhealthy conditions. And so a tutela was filed. And of course, the lawyer said, well, there is not a right to a good sewage system. This is not a constitutional right. And the court said, yes, there is not a constitutional right to that, but there is a right not to risk, to be in danger in the life, because if a child eats what you can imagine, can become very ill and die. So we can link the construction of the sewer system to the life of the children, and because of this connectedness, the court ordered that the municipality finish the construction of the sewer system. The money was there, the contract was there, it was mere negligence. So the court ordered the culmination. So this gives rise of a bunch of cases where a social right is connected to a basic fundamental right and therefore becomes justiciable. Then came well, there are a lot of cases, but in the next development is what we call the IDP case, is the internal displacement persons case. So because of the armed conflict, there are a lot of internally displaced persons, and these persons started to use tutela, millions of persons displaced. Over hundreds tutelas arrived to the court. The court cumulated the tutelas and rendered a decision declaring an unconstitutional state of affairs. What is that? Very quickly. So, as you can imagine, the Constitution says one thing and reality is quite another. There is a distance between reality and the Constitution. It's very difficult for a judge to change reality with a magic wand, cannot do. But the judge can say, and this is what happened here, the court can say, what happened if the reality has certain characteristics? Can we intervene or not? And the court said, when there is a massive violation of multiple rights that affect hundreds, thousands, or millions of persons that are comparable and similarly situated concerning this massive violation, and the resources of the state are very scarce, clearly insufficient to address this massive violation of rights, and the bureaucracy is clearly incompetent to act in the face of this massive violation, there is a state of unconstitutional affairs. Will the court change reality? No. The court will design complex remedies to generate a dynamic so that these aspects that I have mentioned, precarious institutional capacity, absolute lack of resources, and massive violation of rights is addressed, and imparts orders, gives times, does a follow-up of what is happening. So in this case, of course, if you are an IDP and you have to go from the place where you live, you lose civil rights. You cannot reside where you wanted to reside. You lose your crops. You're a peasant. You cannot eat. Your right to food is clearly affected. You don't have access to the hospital or to the school. This right is affected. Perhaps if you have a card to vote where you used to vote, you cannot vote there because you have to move to another city, so you don't have the right to vote. And then there is a bunch of rights that are affected. You have access to your house because you have to leave your house. So civil, political, and social, economic rights are affected. The court said they are all together. There is an interdependency of all rights. And the court issue orders to protect the rights of the internally displaced persons. Very complex orders. So, for example, the court had to deliberate on whether to order the Minister of Finance to spend more money. So the court said, I cannot do that. This is not my competence. I cannot fix the amount of money that the Minister of Finance must invest in IDPs. So the court drafted a remedy in this way, said, it's clear that money is not enough. The Minister of Finance and the head of the planning department must make an estimate of how much money is needed. And they have 1 year to do a very careful technical estimate. And after 1 year, they must go publicly and say how much money is needed to start amending this very grave problem. They have a chance to say, it's so much money that we will not spend it. The court gave this possibility to the ministry, but must do it in public, facing public opinion. A year passed, and the Minister of Finance and the head of the planning department convened a press conference and said, we have to spend this amount, it's huge. We cannot spend all what is needed, but we will spend this amount. We will increase our budget for IDPs in this amount. And in the future, we will engage in incrementally increasing the budget. And so it was the decision of those that competence to spend more money because of the way the remedy was drafted. Secondly, the court could not, in this case, say all the public entities must address the issues of housing, education, health, food for the IDPs. Can order all that. Could order them to design policies to address the specific situations for them to do it. And the court did that and included a process of participation so that IDPs could have a say, could be heard on what they needed and how there should be a response to what they needed. And the court did a follow-up on that. There is the health. Health was in connection with life and integrity protected, connectedness. But then the court said, well, really health, because of different reasons, I don't go into detail, is a social fundamental right that cannot be expanded illimited, can be limited as any fundamental right, establish criteria for establishing limits, and address the failures of the health system. What was happening in Colombia is that if you were poor, you had access to a health plan. But if you have money and contributed to the system, you had access to a health plan that was twice as big as the health plan for the poor. And the court said, this is inequality in the right to health. This inequality must end. Is inequality based on income? This is unacceptable for a fundamental right, and order the government to design a policy to end this difference, not immediately. Could take time because it would take money. So order the government to do that. Second problem, the Minister of Finance was very happy with the good statistics that he had. And he was not sending the money to the hospitals so that the hospitals could work. So the court said, you cannot keep the money that the Congress said was for the health system in your pocket, invested in bonds. You cannot do that. You should ensure the flow of the money in respect of what the Congress has decided should be appropriated and expended in health. So order the minister to ensure the flow of money, to ensure the effective enjoyment of the right to health. So here what we have is a protection of a social right considered fundamental with three obligations: the obligation of respecting the right, but moreover of protecting the right. That's why the regulation had to change to establish a system of the protection of the right in equality concerning health. And third, the right of fulfillment, the obligation to fulfill the right, which in Colombia means the effective enjoyment of the right. And this means that money should flow to the system so that there is access to health. Water. The court had said that water could be protected by connectedness, but there was circumstances in which no drinkable water was accessible for peasants. So if you live in a city, okay, you have your, but if you're a peasant and so the access to potable water for peasants was very bad. The court intervened and said, water for humans, drinkable and potable water, is a fundamental right in itself, and imparted an order for, in the respective region, to create a system so that peasants could have access to drinkable water. Not water for the animals. No, that was another matter, but for the human beings, there should be access to drinkable water, even if you live in rural areas. I stop there. I know if there are questions, or so I go to, yeah, please.
When it comes to understands, it's always important to come to a vital minimum standard. So, as a former church, how do you respond to this kind of challenge? Like, some people say, oh, do you think I need minimum standard perhaps?
That is a very important. What the court did is, I am not going to invent the minimum standard. I will look at what Congress has decided that is the minimum standard, and I will ensure that this is taken seriously and implemented when the issue arises, and an individual will lack food and will lack basic conditions if this minimum vital is not taken into account. So it's not the court creating a standard, but is taking from what the political process has decided is the standard and making it enforceable, not through administrative law, but through constitutional law. Well, indigenous peoples' rights. Here, the court is a very important topic. We have plenty of cases because we have so many indigenous peoples, as I mentioned at the beginning. And so to try to present this in fairly 15 minutes, if I can, I organized the presentation in two parts. First, a conceptual one, and then some cases to show you what happened. Conceptually, what the court has done is to reject the application of the Western perspective to indigenous peoples. The court has said, we cannot impose on indigenous peoples the liberal Western conceptions that we have in Colombia, because they have a different vision. We cannot say you should behave this way or believe in these things. No, we should, as a court, respect and incorporate the perspective of each indigenous peoples. We will be very careful of being colonial, let's say. We cannot be the colonialist, the court. We cannot be the colonialist. We should be very careful. Second, the court said, okay, one way of not being colonialist is to accept that what is considered the right of an individual in the liberal tradition may be the right of the collectivity in the non-liberal tradition. For example, the right to life. The right to life is the right of an individual. But for indigenous peoples, the survival of the community as a whole is what permits these indigenous peoples to survive as indigenous peoples. If the community disappears and ends, each individual may become perhaps a beggar or I don't know, whatever, live how this person can in a city, but it will not be a member of the indigenous community that gives this person its identity, its way of life and of survival. So the right to life is the right of collective subsistence for the indigenous people. And this way, the court started to look at different rights and to, let's say, attribute them to the community, the indigenous people's community. And in addition, the court said, and this collective right to survival is fundamental. It's a collective right, and usually in the liberal tradition, collective rights are not fundamental rights. But for indigenous peoples, the court said, it is fundamental. So, again, non-classical liberal approach. Third, the court said, well, what are we going to do with the claims we receive from indigenous peoples? And the court said, we are going to assess the claim from the perspective of the cosmovision of the indigenous community. Since we as a court are ignorant about this cosmovision, we will ask the leaders of the community and the anthropologists that are experts in the community and the universities that are around the area to explain the cosmovision. And we will give value to this cosmovision and try to decide respecting the cosmovision, not imposing our perspective, but from the point of view of the cosmovision. And cosmovision is very important because it's a powerful concept. Imagine, cosmovision. It includes everything: religious, way of life, relations with nature, traditions, creation of norms, relation with the bigger communities. Everything is there. Third, the court said, indigenous peoples have their traditions that create norms. These norms should be valued as such, even if they are totally different to the ones that are predominant in our. And secondly, they have their jurisdiction. And this indigenous jurisdiction can apply the indigenous traditions, indigenous norms. and we must respect that. If there cannot be harmony between what the indigenous people's cosmovision entails and what the general rules of the society entail, there can be ethnocultural exceptions. And we could carve an exception to allow for the protection of indigenous people's rights. And finally, since all this is so complex, in certain cases, the court said, but it is not for, let's say, the Minister of Health, the Minister of Environment, the Minister of Government to decide on all that. When certain projects, very important projects, are going on in areas where indigenous people live and have a direct impact on indigenous people's lives, the project cannot start. For example, a mining project, an oil project, a gas project, cannot start without prior consultation with indigenous peoples, so that indigenous people say, listen, this project will affect me in this way according to my cosmovision. Let's try to find a way. The court has not ordered consent of the indigenous community, only prior consultation, unless the project will affect the survival or the basic functioning of the indigenous community. In this case, consent of the indigenous community is needed. It has not happened very often, but sometimes the court has said, this project requires consent. It will really totally affect the indigenous community. So either you move or either you want to stay there, try to find the consent. These are the basic, in a nutshell, the basic conceptual elements that the court has used. I don't know if there is any question or I go to the case. Yes, please.
I wonder the relationship between these, specifically the cosmovision proposition and your earlier liberal progressive cases, because of course, in typical Western jurisdictions, you have that conflict between the progressive cases and conscientious objection. How does that work here when it's liberal cases versus cosmovision? And I'm curious if there are cases like these.
There are, and I will go into them. Plenty. So let's go through the cases very quickly. Good. I have a bunch of cases here, but I will focus on them. So the first case, also in the beginning of the year, was a highway was being constructed near an indigenous community and was affecting the crops of the community. There was no prior consultation, and the court ordered the highway to stop until there was consultation. And it was the bank. Oh my gosh, how are you going to stop a highway? It was the bank. Things happened. The highway was finally constructed, had to deviate, do things, and there was an accommodation there. Then came a series of excuse me. Then there is this, let's go to these very controversial cases, very important cases concerning also consultation, which I call it the blood of the earth case. Okay, is not the title, the formal title, is the title I used to grab your attention. So there was oil exploration in an area where the indigenous community, the Uva community, had territory, recognized territory by the state. There was no prior consultation. So there was a tutela, got to the court, and the court basically said, what is the problem here? And the indigenous community said, listen, according to our cosmovision, what we have in nature does not belong to anyone, neither to private persons, not to the state. It belongs to God. And we as a community are the guardians of the harmony with nature. And moreover, you cannot take oil out because in our cosmovision, oil is the blood of the earth. You cannot take the blood of the earth out. Of course, the court could have said, you are crazy. You are crazy. How do you say that? But since the cosmovision is taken seriously, the court said, we must respect your cosmovision. So let's try to start away. Prior consultation was established. There was a whole process. I will not go into the details. And there was accommodation for the project to move. Really, the project had to move, had to move to other places. The company had to spend a lot of money to be able to move, and the community should also tolerate a project that was not within but near the territory. There was accommodation there. The wooden stock and the purifying light. These are, go to your point, they are types of sanction. Wooden stock, I don't know if there's good translation, called in Spanish, cepo, is you are punished going into wood with your head there and your hands. That's, I don't know if the correct translation. We call it in Spanish the cepo. The purifying light, really, it was a punishment like this, using a whip. The individual was whipped in the leg. He was whipped in front of all the community. That was the punishment. It was a corporal punishment. It was a huge controversy. The tutelas went to the Constitutional Court, and the Constitutional Court said, these two corporal punishments can go. First thing. Why? Because according to their cosmovision, they have different meanings. I go to the purifying light. The purifying light, the court said, this whip is exercised in a soft way. It's not that you are inflicting a lot of damage and pain when whipping. The whip is not in certain parts of the body here, it's in the leg. And the whip is done in front of the community because in this community, the whip represents the light that purifies the person that has committed a crime and that after purification can become part of the community again. It's a kind of restorative justice. Of course, this is unacceptable for us from a liberal Western perspective. This is not for everybody, but in this indigenous community, it has this meaning. So it can go on. It's accepted. And the indigenous jurisdiction can impose this punishment. The case has other complexities, but I go further. Then came very difficult conflicts with other rights of other communities. In this case, religious communities that were evangelizing, preaching. The court said, well, I don't pick all of them. I take the most interesting, which is preaching on top of rocks. This is a situation in which a very important indigenous communities that live high in the mountains, and that's a very significant tradition and history in Colombia, decided not to allow evangelization. Evangelization had been going on there since colonial times. Suddenly the heads of the indigenous community say, no more. The preacher cannot enter here, not accepted. Well, there was a conflict because some members of the community wanted to talk with the preacher, wanted to preach. And so there was a tutela that went up to the court. And the court said, in a unifying decision, is, well, first point is that we must respect the cosmovision of the community. Why the community doesn't want the preacher to go in the territory, not only because it's the territory of the indigenous community, but because the preacher behaves in ways that does not respect the meaning that nature has for the indigenous community. For example, the preacher arrives and sits on a rock and starts preaching sitting on a rock. You cannot do that because the rocks, according to this community, have certain meaning, and you don't sit on rocks. That's not done. The preacher does this. So it was an enumeration of the things that couldn't be done. So it was not only a territorial thing, it was a protection of the meaning of nature for the community and the respect of this meaning. Secondly, what to do with the indigenous that wanted to talk with the preacher. So the court said, okay, if an individual member of the community wants to listen to the preacher, wants to read the Bible, can do. Must go out and do it in a way that does not affect what is the cosmovision of this community in the area where the community lives. And this was the balance. There are, of course, a very long decision with other elements, but it shows how seriously is taken this cosmovision thing. Then I jump others. I go for the access to food and water case. This is a case in which children of an indigenous community in the area of Colombia where there is desert were dying basically for lack of water and food. There, the court said, well, I can intervene and I will intervene, it is a variant, saying that there is a state of unconstitutional affairs because the state has not done enough things to allow food and water to arrive to this desert. You cannot develop Colombia in a way that the desert is isolated and therefore there is no food and water arriving to the desert according to the traditional ways the community lived. So the court intervened and said there should be policies for allowing and satisfying the access to food and water, and created certain indicators to show that the state was behaving in a good way. Of course, there are huge controversies concerning evangelization of nomadic communities. I will not go into this area. If there's interest, I can go into that. But we have several nomadic communities. And the big problem with nomadic communities is that they claim that not a specific part of Colombian territory is their area. Since they are nomadic, they claim that their territory is a huge part of Colombia where they go. What to do with that? So in a case, the Constitutional Court, and of course, in this area, there are plenty of economic activities, plenty of urban activities. So the court intervened in a case and said, first, we must recognize that this community is nomad and continues to be nomad. You cannot change that. So their ways to move should be respected and open. Secondly, there are economic activities going on in certain areas. They can continue. There will not be prior consultation. It's impossible because the case arose in a situation in which the economic activities have been going on for at least 15 years. So the court said there are going to be post-consultation. And the economic organizations, basically in coal, should consult with this indigenous community. How are they going to accommodate so that the economic activity does not affect the ways of the nomadic, and measures that allow the nomadic communities to preserve their way of life in this very open section of the territory. There are other cases, but I stop there. There is, I hope that I address a bit your question. There is one perhaps more specific, I didn't have it, which is abortion. Abortion. So there was a tutela by a woman member of an indigenous community that was underage. And therefore, according to rules of the community, couldn't make a decision on abortion without the consent of the elders. And there, it was a very tough decision. The court intervened and said, we should give value to these elements of the community. But there should be a process that will give to the woman a capacity to decide. We are not going to automatically say, listen, the elders do not have a say anymore. We are not going to say the woman decide by itself and that's it. The woman has a right. We protect the access to the abortion, and there should be a process of discussion that values this right and respects this right, but in a dynamic way. It has happened in other cases concerning twins. So there is a community, also a nomadic community, that considers twins evil. Imagine you have a nomadic community and you have 2 children. How could you move? So in this nomadic community, if there were twins, they were abandoned. They were considered evil. Of course, the entity in charge of protecting children rescued 2 twins that were abandoned, babies. And there was a conflict. And the court intervened and said, we are not going to teach this community that twins are not evil. We are not going to try to change their cosmovision. But they cannot be, the babies cannot be left to die. So there will be a commission of anthropologists and social workers that will take care of the babies. And there will be a dialogue with the heads of the community. And in this dialogue, a decision will be taken. We are not going to impose any decision. A decision will be taken. This decision can be that the indigenous community regains the babies and keeps the babies. Or the decision could be that they will not keep the babies, but the babies will not die. Someone will protect the babies. So it's this kind of accommodation that the court has tried to do in this difficult conflict. So it's generated dynamic without imposing a result, but preserving, trying to, in this dynamic, lead to a reconciliation of the right's intention. That this is, sometimes it goes well, sometimes it doesn't. It doesn't go well.
And as a Colombian myself, I enjoy your remarks very much. And I just want to ask you about indigenous land holdings, particularly in the Pacific coast. In Chocó, Cauca, Nariño, there's like that. So the Constitution in 1991 creates collective land rights. And that has basically made that part of Colombia uninvestable. And with that, it has aggravated poverty and lack of access to food and water, and also the conflict zones. So how can the court resolve that kind of tension between the collective rights of the Afro-Colombian and indigenous peoples in that part, and also the right of individuals for development and access to basic services? And
yes, this is a very difficult area, as you mentioned, because we have the indigenous communities. We also have Afro-Colombians that in this area are protected collectively. So they also have right to collective land, the Afro communities, and there are tensions between the indigenous and the Afro-Colombians for land. And of course, there are very important developments in the area. So it's not for the court to solve this tension, but there are cases that have reached the court from this area. And in these cases, what the court has said is there can be a development, but with prior consultation. So you must listen to the community and try to find an arrangement that is satisfactory for both parties. You don't need the consent if the survival of the community is not at stake, or the basic integrity of the community. This has been the approach of the court. Of course, in practice, what has happened is that there are certain more radical individuals that do not want to reach an agreement. And in practice, some of these individuals are not members of the community, but are, let's say, activists that want to preserve the communities and exclude development of the area. So there is this political element at stake that makes in this area of Colombia and others very difficult the implementation of the prior consultation, because sometimes the indigenous community will find a way, but if there is an activist there that wants to stop, let's say, certain activity because it's against this kind of economic activity, there is radicalization and things take longer. But the solution is in prior consultation. So it's allowed to development, but with prior consultation.
Thank you so much for your talk so far. It's been really interesting. My question is, has the court ever had to decolonize customary law itself or customary practices? And if so, how did it go about this?
Had the court what?
Had to decolonize customary law or customary practices?
Decolonize.
Yes.
Well, it's a very interesting point because it depends on each community. Some communities have not incorporated anything from the Spaniards, from the colonial, nothing. So the nomads in the Amazon didn't incorporate anything from the colonial power. There are other communities that have incorporated elements of the colonial power, syncretic if you want. But they assume these practices as own. So, for example, the punishment that I mentioned, the stock, this was not an indigenous community punishment. It was adopted from the colonial power, but the indigenous community ended up believing that it was their practice, their tradition. So the court there respects. The court doesn't judge what the community thinks. There are certain circumstances, very difficult, in which the court has not accepted. And it doesn't matter if it is colonial or not. It doesn't accept the practice. As I mentioned, for example, abandoning the twins. The court doesn't ask for the change in the belief. It asks for a dynamic, so something happens. But there is no colonization. It's the belief that they had. It has happened also with oblation. There is a community where oblation is practiced. And the court said, well, what to do there? So it was a process in which the court, with the United Nations, generated a conversation among women, because the practice was transmitted from woman to woman. It was the elder woman that taught that. It was a woman thing, not a man thing in this community. And so there was a dynamic of conversation to see what happened, and perhaps the elder woman would not transmit this custom to the younger woman. I don't know the final result, what happened really, but it's this kind of thing. So the court does not impose, does not try to change, but generates a dynamic, and perhaps something will go out of this dynamic and establish certain parameters, certain limits on what had happened.
Perhaps my question is also related to what you just said. Just now you mentioned that the cosmovision of indigenous community is also fluid and it's also flexible. So I was wondering if there have been cases where a cosmovision has been contested within a community itself, and
Yes.
Whether and how would the court then, make a judgment on what is the cosmovision of a community?
Yeah. So the punishment cases arose of challenges of members of the community against the authorities of the community. So in the purifying light, the lashes case, it was the individual of the community that filed a tutela against the heads of the community. This individual didn't want it to receive the punishment that he was going to receive. That's precise. So the individual said, but the individual didn't challenge the cosmovision. The individual said, I know that in my community, this is the punishment, but I don't want the punishment. I don't want this kind of punishment. I want other punishment. So, and there the court, what does is consults with anthropologists, with members of the community, and there is an evidentiary process. A lot of evidence is gathered for understanding what is the cosmovision. There is deference to the cosmovision of presented by the experts and the leaders of the community.
I'd like to ask a small proposal for that. What if there are genuine evidentiary disputes?
Genuine evidentiary disputes, yes. Yeah.
So what do we do?
There the court tries to assess the evidence with, let's say, different criteria of evidence. We don't have the preponderance of the evidence. We don't have this kind of standards. But the court looks and, for example, let's say consults 10 anthropologists. And there are 2 that say one thing and the others say other thing. So perhaps the court goes with the 8. Unless, for example, the 2 are the foremost experts on this community. There the court generates a new dynamic, invites other experts, and tries to clarify the position. But always in case of doubt, the court tends to be different to what the leaders of the community present as a consensus of the cosmovision. So to finish, yes, sorry, it took to finish because we are there. I will jump from, go through the sustainability. Of course, the big question is why the Constitutional Court has been able to do that for 34 years and continues to do it. Why it has been sustainable? I leave this question for the future. I finish saying that in conclusion, what we can see is that the court has followed a very inclusive approach. The court tries to protect everybody. It's not a court that sides with just the weak and against the powerful. No, sometimes the powerful win if they have a right. It has been clearly anti-colonialist without imposing a transformation when some elements of the colonial period has been adopted, respecting the autonomy, the cosmovision of the indigenous community, has been pro-democracy, of course, has been pro-equal dignity. And what is important is the court has built in a tradition of judicial review. And if one would try to answer why the court has been sustainable, this for me would be one of the key points, is the court has worked within a 100 years tradition of judicial review. It's not something that appears suddenly. So there is in our political culture, in a legal culture, a solid basis for what the court do. And second, since it has been very inclusive, although it has produced the transformations that you can deduce of what I have said, it's difficult to not accept this conclusion. Is the Constitution protects everybody, and the court has tried to respect and protect the rights of everybody. It's difficult to say this court is on this side. No. Even very powerful have been protected, as the weak have been protected. This allows the court to continue its activities. Well, sorry, it took a bit more, a bit more, and thank you for your attention.
This is absolutely fascinating. Really, please, another round of applause. Please join me in this really animated and illuminating lecture. It's now 8:30, but we have one more question from Evelyn in the audience. Is it Evelyn? Yes, Evelyn. So she's been waiting to ask this question. So one final question.
Okay. Sorry, I'll just make the question very short. So I understand that courts often consider policy reasons, but sometimes the court needs to balance the reasons for two minority groups that the court want to protect. So the two groups are they are in conflict, but they are also two very vulnerable groups. So my question would be like, what is the most difficult challenges for the court to balance the demands, but at the same time do not give a wrong message that they are putting one party over another in deciding the case?
It understood very well because
So how to balance interests of two vulnerable groups.
of two vulnerable groups.
Yeah, two groups.
It has happened. Well, the court applies proportionality. I don't know, you may imagine that you're all here. So applies proportionality. It has developed proportionality, is a mixture of three things. The German elements of balancing and tiers of standards and tiers of analysis of the Americans, and some Colombian inputs. So we have proportionality. But in our proportionality, there is a very important element. It's contextual, even in abstract judicial review. So the court takes very seriously the facts of each vulnerable group, and in this context tries to assign value and apply proportionality to the competing constitutional claims at stake. And the court, it basically has a rule, is it should be, the decision should be a decision that, if possible, never sacrifices the right of one for the right of the other. This is, if possible. Sometimes it's not possible. Sometimes the court ends and has to make a decision. But if possible, tries to find the balance and not sacrifice the right of one for the right of the other. This is the short answer to your very difficult question.
Thank you so much, Justice Cepeda. That is
Very much. Thank you.
That is phenomenal. I think with the amount of interest that you've elicited, if we were to take all questions, and I have 12 on my list, you would miss your flight tomorrow morning. So I think we'll have to invite you back, and we look forward to keeping in touch with Justice Cepeda. And thank you again for your participation. Thank you very much, and thank you again.
Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you. Thank you.
Forgot to project where you can find all the decisions. Of course, in this page, you can find all the decisions I mentioned, and I have the list of the decisions here. If someone is interested,
Okay.
yeah. If
Okay. Thank you.
you want to share, please feel free.
Thank you.
Thank you.